All right, I want to welcome former federal prosecutor Neama Rahmani, who is here with us. Thank you for joining us, Neama, as we discuss this case. And one of the things that I want to talk about in this case is, again, there's been no real why or motive, but we know that's not a legal element of the charges that he is facing in the death of all four of these employees. But do you think it makes a difference for a jury not to have a why?
It does, Judge Ashley, and this is a small town there in North Dakota, and this is one of their own, and there really is no motive in this case. I mean, there's plenty of evidence to support the state's theory, particularly the evidence that was seized during that search warrant. So I still expect these jurors to return a guilty verdict, but that is a question they will be asking in that deliberation room. Why? Why did Isaak, a chiropractor that really had no connection to RJR, engaged in this brutal and heinous murder of four innocent people?
Yeah, I agree with you. They are going to ask that question. I can always visualize, too, that some may be saying, but why? And someone else is saying it doesn't matter why. We have to look at the evidence. How do you feel overall that the prosecution did in presenting the evidence for the jury to consider?
Judge Ashley, I liked how they presented the case. Obviously, the defense came after them pretty aggressively, but they really hammered home the strong physical evidence that was found in Isaac's truck. And, you know, as the prosecutor said during summation, this was a very unique vehicle, unique rust markings in particular, so much so the law enforcement in a neighboring city was able to identify it as his chiropractor and the chiropractor of his parents. So this isn't a vehicle, notwithstanding what the defense said, that there are thousands of. And let's not forget what they do have. They don't have motive, but you don't need motive to prove murder, just like you don't need a murder weapon. But they have blood in his vehicle. They have orange fibers in his vehicle. And let's not forget what they found at the house, the treasure trove of evidence, and particularly the exact number of shell casings that were used to kill these victims, in addition to the distinctive orange hoodie, the mask, the knife that was bent that had been cleaned with bleach. So there's plenty of evidence here for these jurors to return a guilty verdict. Judge Ashley, you nailed it. And Shanley's been there for the past several weeks, so she can see the jurors' reaction. But we spent so much time in this case talking about the video, the original video, the edited video. Was it doctored? You know, why did law enforcement, signal out or choose specific pieces? Should that have been admitted? I mean, there were days of testimony about this. I mean, the defense wasn't giving anything up. But one thing I think they did an outstanding job was the side-by-side. March 25th and April 1st. Literally to the minute, the suspect, who we believe is Isaak, is following the same path. That has to be very compelling for these jurors. Again, I couldn't see their reaction. Shanley could, but that's something that was very powerful evidence, in my opinion, when the particular witness was testifying. And really, we saw that side by side. So I think there's plenty of video evidence in this case, both at the scene of the murder, obviously the McDonald's, that was good evidence as well. And that's, I think, something that is going to be able to convince these jurors to return a guilty verdict, and is precisely why the defense objected and resisted to its introduction at every possible moment.
Is that an important piece to communicate to that jury as your last words?
Judge Ashley, when I'm delivering my closing statement to jurors and my argument, I like to tell them, look, focus on the evidence that we have. Don't get distracted by defense counsel's arguments about motive. You really don't need it. Or other video evidence. There's murder convictions without any video evidence. What the defense likes to do is try to poke holes through all these arguments against the wall, hopefully get one of the two jurors distracted and they go down this rabbit hole. They're following this red herring, but ultimately it really doesn't matter. You want to argue to the majority of the panel and give them the tools that they need when they go back into the deliberation room and say, listen, we've provided everything to you. There's no question. I mean, we spent days discussing these videos and having witnesses come lay foundation because the defense wasn't stipulating to anything. The jurors saw this. They know this. So there's certainly no evidence that the prosecution was hiding the ball or not providing some information to these jurors. So again, I understand why defense attorneys make these arguments. Sometimes the best defense is a good offense, and they really went after the prosecution, saying this is sloppy investigation, rushed to judgment, the scene was contaminated, these were rookie cops. But ultimately, especially in a jurisdiction like this that respects law enforcement, I don't think that will carry the day for the defense here.
All right, and it is a smaller community in North Dakota. Any last thoughts, Neama, that you may have on how long you could guess the jury might deliberate in this case?
Judge Ashley, given the arguments of counsel, I would really be surprised in a case like this, one of the most violent cases in North Dakota history. If the jury returned a verdict today, that would bode very well for the prosecution, and I would expect guilty verdicts across the board. Given just the sheer volume of evidence here, assuming this is a deliberate jury, I would expect this to continue till tomorrow. But if you're the prosecution, you really want to get that verdict in before the weekend. As this drags on through the weekend and next week, that's a sign that there may be one or two or more holdout jurors.
All right, thank you. Let me first ask you this. You are a former federal prosecutor. They don't play, and I know there's decorum and respect and professionalism. Were you surprised to hear the court really admonish Lewin this morning to say you can't have the volume and the physicality that you've been demonstrating while you've been examining the witness?
Judge Ashley, I'm not surprised. And I'm here in Los Angeles, and this is happening literally down the street from me. But John Lewin, I respect. He's an outstanding prosecutor, one of the best cold case prosecutors in the country. But he's been living and breathing with this case for so long. Let's not forget that he flew out to New Orleans when Durst was arrested and personally interviewed him for 3 hours. That just doesn't happen. And there's been a lot of accusations of impropriety and ethical lapses between the attorneys. It's gotten really nasty here. And Judge Wyndham, really nice judge, but I would really like him to get a little bit more control over the courtroom. And this was one of my concerns. Lewin can be aggressive. He may come across as a bully to these jurors. And this is not the same Bob Durst that, from 1982 or the early 2000s when he allegedly committed these murders. This is a frail old man. He's in his late 70s. He has very significant and clear health issues. He's there with cancer. He has a catheter. He can't even urinate normally. So, if I were Lewin, I would just be very cautious about how to go about this cross-examination. I know he's been waiting for this day for years. He has literally a 200-page cross-examination outline, Judge Ashley, and he has plenty to go after because Durst testified for almost a week. Obviously, there's the portions of that 3-hour interview. He gave statements during the Jinx documentary, but he's really got to be careful because the defense strategy in this case is to make Bob Durst appear sympathetic. They've done a very good job doing so. So Lewin can't cross the line and alienate these jurors who may think, hey, this looks like my grandfather or my uncle.
Has in fact testified on cross-examination that yes, he would lie, and so that certainly has come out through Lewin's cross-examination. I must ask you though, because there's a lot of talk and the social media that I follow and watching all of our programming here at Court TV, and there's been some that have said, why isn't anybody calling a spade a spade? Isn't the jury going to see that this is an entitled billionaire that is putting on an act, basically? And so tell me a little bit about that. I know that you're concerned about Lewin may alienate because it's a sympathetic older gentleman that has health issues. But on the other hand, I think there's a good argument to be made that they may view him as an entitled billionaire who chose to get food stamps when certainly he didn't need those. Someone else might. What does that do to this case?
Judge Ashley, I agree with those commentators on social media, and that is exactly the district attorney's office, their story, their theme in this case, what they want the jury to believe. There's a reason Lewin is talking about Bob Durst shoplifting, Bob Durst using food stamps, even though he's a multimillionaire. This really strange behavior, the fact that he didn't care when his best friend Susan Berman died or his wife Kathy disappeared, how he chopped up Morris Black, dismembered that body, threw it in the Gulf Coast, and everyone found his head. So the state wants to dirty up Bob Durst, make him unlikable. This is a tough circumstantial case, and it's going to come down to two factors: likability and credibility. And you nailed it on credibility. Lewin scored some very good points on cross-examination where he got Durst, who had to admit that he lied, and he would continue to lie had he killed Susan Berman, but also about likability. We talked about the defense theory, and the defense is doing a good job. They're referring to Durst as Bob. This is something the judge allows. Normally, unless you're dealing with minors, Judge Ashley, you can't refer to a party in a criminal case by their first name, but this is something that the judge is allowing. They really want to humanize Bob Durst, and Lewin and the district attorney's office, on the other hand, want to do the opposite. Really tell these jurors that this is a monster, this is someone who's killed 3 times, and this is not someone that you should like or trust. Rules just don't apply to Bob Durst. And we know this because when he testified in Texas and he said that I killed my neighbor, dismembered the body, mopped up the floor, put it in trash bags, and disposed of the pieces, the jury returned a not guilty verdict on the most serious count. They believed him that he was acting in self-defense. And that was a much stronger case in terms of the evidence. And I would also argue that the Kathy Durst disappearance is a stronger case. Susan Berman is a very challenging murder case. There's not a whole lot of direct evidence. You have the cadaver note, you have the admissions and the jinx, but that's about it. And you're dealing with a criminal defendant who is a veteran of murder trials. He knows how to testify. He's spent years preparing himself, and he has an all-star defense team of DeGuerin, Chesnoff, Lewis, and again, John Lewin's fantastic, but this is why I'm so fascinated by this case, because the attorneys on both sides are outstanding, and you have a criminal defendant who is smooth, who is polished, and when he gets up there and testifies in his very folksy way, he's very likable. So I don't think some of the same rules that apply to other criminal defendants apply to Bob Durst.
Is there anything that you found was a glaring missed opportunity by either side?
I think the defense dentist appointment argument was a bad strategy. You know, the defense did a good job cross-examining the law enforcement witnesses, talking about the affair, talking about, you know, the ex who was in prison, talking about the disgruntled tenants, all these other possible people that might have had a motive to commit these heinous acts. But when they put on their case and they put on Isaac's patients, and the patient said they received a call on Saturday. You know, Chad Isaak canceled their appointments for Monday. This was obviously the day of the murder, April 1st, because he had a dentist appointment. That really opened the door for the prosecution to come back during rebuttal, call someone, the office manager, I believe, from Chad Isaac's dentist office, and that individual, that woman, she came up there and she testified that Chad Isaak did not have an appointment on April 1st. He was not there on April 1st. So really the sort of alibi that they were trying to pursue really ended up going sideways on them. And I think the state really gained a lot of ground. And I think that's something the jurors are not going to like. The fact that he lied to his patients, the fact that he made up this dentist appointment and really did not go there, it was something that the defense, I think, lost the opportunity. They should have just stood pat with what they had as opposed to sticking their neck out, because I think they lost a lot of ground during their defense case.
What are your thoughts, especially given you're in the backyard of this trial?
I agree, Ashley, and we've seen motion after motion by the defense arguing physical incapacity, that Durst is so frail, he's so old, he's unable to testify. And even the judge, Judge Wyndham, sort of laughed at that when Durst has taken the stand now for more than a week and is testifying very well. I mean, regardless of his physical issues, he's clearly sharp as a tack, and he's doing very, very well, both on direct and on cross. So we can set all that aside. But, you know, as we've discussed, this is a case where, you know, sometimes as an attorney, you consider your profession a business, but Lewin is clearly taking this case personally. And that's why we're seeing some of this back and forth with both him, his Durst, his attorneys, as well as the court. And the DA, they need to argue that, no, Kathy's a stable person. She was committed to her medical school. She wouldn't have just gone girl and not showed up to the first day of a very important internship. So this is all fair game, and I agree with Lewin on his strategy here to really argue that Kathy was not a drug user, or certainly not an addict, and that she was very stable and would not have engaged in any of this erratic or bizarre behavior that the defense is trying to argue.
I know, again, given you're in the backyard of this trial, tell us how different in other respects this case might be from ones that you go and represent parties or know of happening in the courthouse. Is this unusual in a lot of respects, or just break that down for us if you would?
Ashley, it is unusual, and Los Angeles, like Seattle and Kirk, is very liberal, and judges generally, especially in state court, give the attorneys broad leeway to conduct their examination. But Judge Wyndham has taken a very, very broad view of relevance, right? We've watched parts of All Good Things, a fictional movie. We've watched most of The Jinx, a documentary, arguably fictional. We're talking about really Susan Berman's murder, but we're going back to Kathy Durst, and even Morris Black, a case that was adjudicated and Durst was more or less exonerated. So really anything goes in this particular courtroom when it comes to evidence coming in, the length of examination and so forth. And one of the reasons, I mean, Judge Wyndham is just sort of a nice, calm, type judge. He's not one of those old school harsh judges, but really he wants to allow the parties to present their evidence because the last thing he wants to do is to have to retry this case because a particular piece of evidence was not allowed in by the defense. Weinstein production, my mind was blown. There's many very strange and unique things about the Durst trial, and that's certainly one of them. This was something that was unexpected, and I've never, ever seen in the thousands of cases that I've handled. It was the testimony on Tuesday when Bob Durst said that he lied under oath, and if he killed Susan Berman, he would lie to this jury. That was the most effective cross-examination that I had seen to date, and really the most compelling evidence that I'd seen to date, because really we knew when Bob Durst took the stand, just like we saw in the Morris Black case, this case comes down to his testimony. And I think John Lewin scored some huge blows on Tuesday afternoon here in LA.
Do you think that any part of you would have been tempted, if it had been you, to sit down with that and leave it at that and not ask all the other cross-examination? Or do you think that there's been so much presented thus far that you would go ahead and do all the rest of the questions? Because that's a powerful point to just stop, right?
I agree completely. And sometimes as a prosecutor, you want to quit when you're ahead. Less is more. But we know Lewin can't help himself because he's been waiting for this moment for years. So he's going to go through every witness, every piece of evidence, every single question in that more than 200-page cross-examination outline that he has.
All right, Neama, I know that you are done with this for the day. Thank you so much. We always appreciate your expert analysis.